Oh, yes. Yeah. Yeah.
Ada keseruan naonnya bos.
Yeah, hey, you like it. So you
Comrades, the France is the result for leadership.
yeah, we know things happening. I think women are
Leadership. For the chairman of the progress is coming with the business. Chairperson of the province is coming. It's coming to the making myself very the front row reserved for applicants and leadership. Please.
Yeah.
Just check with Just uncheck then I switch I mean, there was no enough preparation for legislation. Now, can you take over where can the entire people that were fired by our much less and they can expire
What do you think is subsequently these things will go on and on.
I don't know what it was. But I mean, I thought from the location, when I was they go and take that
Carry on.
All right.
Sorry, I'll just go. Doesn't this chair much? It's too long.
Parking. How to parking when I sell parking up to now.
calling the matter of Aaron Mutswana and others versus the African National Congress and others, case number 35398 of 2018.
And this is the court I on behalf of the applicant.
Yes, in this matter, I've prepared a written judgment which may be uplifted from my registrar once the judgment has been handed down. The applicants in this application are branch members of the African National Congress in the Northwest Province. They seek an order declaring unlawful and setting aside the decision of the National Executive Committee of the African National Congress taken on 31 August 2018 to disband or dissolve the Northwest Province Executive Committee, the PEC. The first applicant is a former member of the disbanded PEC. The fifth applicant is a former member of the disbanded PEC and the chairperson and the former chairperson of the disbanded PEC. He is also the former premier of the Northwest Province. The second to the 43rd respondents are also members of the disbanded PEC. Now, on disbanding the PEC, the NEC appointed a provincial task team on 20 September 2018. The 44th to 74th respondents are the members of the provincial task team, or the PTT. The applicants also seek orders, A, declaring unlawful and setting aside the decision of the NEC to appoint the PTT, and B, interdicting the PTT from carrying out the functions conferred on it by the NEC and the Anc Constitution. Lastly, the applicants seek an order reinstating the disbanded PEC within 7 days of issue of the order of this court. Now, this matter came before Mashidi J on 9 November 2018 on an urgent basis for interim relief. Mashidi J struck the matter from the roll on the basis of a lack of urgency. He nonetheless observed that the matter is of national significance and should be heard expeditiously. The matter was accordingly set down on the opposed roll on 29 January 2019 for final relief on a semi-urgent basis. Now, the disbanded PEC was elected unopposed on 12 February 2015. The organizational report of the ANC, prepared by Mr. Gwedi Mantashi, the Secretary General of the ANC at the time, and delivered to the ANC 54th National Conference held at Nasrec in Gauteng on 16 December 2017, described the PEC, the disbanded PEC, as follows. And I quote, "The current PEC was elected unopposed, reflecting the hard work of trying to eradicate anarchy. The NWC was elected and subcommittees set up and all PEC members deployed to the regions. The PWC, which was elected in the first PEC meeting after the provincial conference, has been active, optimally functional, and meets regularly to process decisions of the PEC. The NEC deployees are hands-on in doing the work. They have good relations with the PEC and have provided political guidance continuously. The subcommittees are functional and make a big contribution to the work of the PEC. They meet regularly and make visible contribution, that is, organizing and campaigns, economic transformation, legislature and government, and media communication. ... The province is campaign-oriented beyond just the elections. This entailed deploying organizers to support the regions. Overall, though, the regions are uncomfortable with the support as they receive it as a way to monitor them, as they perceive it as a way to monitor them. The membership drive is witnessed by the growth of membership. Now, in the build-up to the 2017 National Conference, the ANC in all of its provinces, including the Northwest, experienced divisions and factionalism within the party as part of the national leadership race. These divisions became particularly marked in the Northwest Province since March 2018. Mr. Obed Bapela, the permanent NEC deployee to the Northwest, writes in his undated report entitled Political Analysis of the Northwest Challenges, and I quote, "The NEC deployees have so far been seized with issues in the Northwest since March 2018. The NWC has made early interventions, and the President has also had interface with the province and its leadership in trying to find a solution to the challenges facing the ANC and its alliance partners. The situation in the Northwest has reached a delicate and complex stage. We are at the point where, as the ANC, we are gravely burdened by the need to focus on more critical matters of the elections. We need to present a united force and help build the confidence of our people that has taken a serious knock in the recent past. But it is also a time when there is a resurgence of renewed hope that the ANC can restore its firm place in the imagination of our people. The Tuma Mina campaign has had some positive effects on our people, and they are more and more pressed to spread the new spirit in the Northwest as well. However, a quick solution is no way likely to help the situation, but a concerted effort over a period of time will go a long way towards unraveling the complexities that obtain in this province. Now, during mid-August 2018, the National Working Committee had undertaken a roadshow across the Northwest province to engage with all the ANC regional structures. On 14 August, the provincial chair of the PEC and its acting secretary received a letter from the Office of the Secretary General informing them of the visit by members of the NWC to the Northwest Province on 19 and 20 August 2018. The letter stated that the purpose of the NWC's visit to the province would be to get and I quote, to get an understanding of the provincial challenges and the state of the organization for its readiness for the upcoming national general elections, close quote. Now, attached to the invitation was a list of questions on the state of the organization in the region and governance in the region. Now, leading up to the Northwest regional visit on 19 August 2018, the respective branch secretaries prepared the attendance registers for accreditation in accordance with the requirements that ANC meetings must be attended by members of the party in good standing, i.e. fully paid up members of the party. In fact, an annexure to the invitation listed the participants for each regional meeting as the NWC, NEC deployees, PEC deployees, RECs, which are the regional executive committees, top 5 of each branch, 5 representatives from the league, being the Youth League and the Women's League, and representatives from branches or regional structures, and representatives from a branch or regional structure where there is more than one structure in a branch or region. Now, meetings took place in each of the 4 ANC regions in the Northwest Province, namely Bojanala, Ingaka Mudiri Molema, Dr. Ruth Segomotsi Mompati, and Dr. Kenneth Kwanda. The meetings quickly descended into chaos and were marred by several irregularities, including these. Verification of membership in good standing was stopped midway and then abandoned due to the intervention by members, amongst others, the Deputy President of the ANC and the NWC deployees attending the meetings. Consequently, numerous people who attended and addressed the meetings were not verified as members of the ANC in good standing. Other irregularities were that duly elected members of the RECs were not given an opportunity to either speak or make presentations to the NWC on the questions raised in the invitation. Furthermore, the reports prepared by the RECs were not presented nor considered, as the NWC opened the meeting to unelected members of the community without verifying their membership with the party or the authority to speak on behalf of a branch. Lastly, non-ANC members and members of opposition parties were also allowed to speak and were consulted in these meetings. Yet duly elected members of the properly constituted branches and regional structures of the ANC were not. Now, following the NWC's visit to the branches or to the regions, a report was compiled by the NWC and presented to the NEC at a closed meeting on 30 August 2018. The report presented by the NWC to the NEC makes disparaging and adverse remarks about the state of the organization and governance in the Northwest Province. It was compiled on the basis of views expressed at the meetings held in the 4 regions that were attended by non-members of the ANC. Now, in making these findings, the duly elected members of the regional executive committees and the branch executive committees who were present at these meetings were not afforded an opportunity to present their regional reports or branch reports and to respond to the adverse comments made about them and the state of the organization in the province. The NEC, informed by the NWC's report, resolved to dissolve the PEC on 31 August 2018. The decision was communicated late at night on 31 August, late that very night. Now, it is common cause that between the NWC's visit on 19 and 20 August 2018 and the decision taken on 31 August 2018, none of the branches or regions were consulted about the impending decision, nor were they given an opportunity to respond to the adverse comments and statements made by community members and non-ANC members of the meeting held on 19 and 20 August 2018. On 20 September 2018, a provincial task team was appointed as an interim structure in the Northwest with the full powers and responsibilities of the PEC. Now, there are 2 bases upon which the applicants seek the declaratory and interdictory relief. The first is procedural fairness and the second, substantive irrationality. The applicants contend that the decision of the NEC to dissolve the PEC was procedurally unfair and therefore unlawful because the branches and regions were not, as contemplated in the ANC Constitution, notified of the impending decision, and nor were they consulted with prior thereto. They furthermore contend that the branches and the regions were not given proper reasons by the NEC at the time of making its decision for why it became necessary to dissolve or disband the PEC. In relation to the substantive legality of the decision of the NEC to dissolve the PEC, the applicants contend that the NEC failed to comply with the requirements of Rule 12.2.4 of the ANC Constitution, which specifies that the NEC may suspend or dissolve a PEC where necessary. The thrust of the argument is that the NEC has failed to demonstrate on the evidence that the dissolution of the PEC was necessary as contemplated in Rule 12.2.4 of the ANC Constitution. Now, the ANC opposes the application on 2 grounds. The first ground is that the application is moot, and the second is on the merits. On mootness, the ANC argues that the relief sought by the applicants has become moot as it will have no practical legal effect if granted. On the merits of the case, the ANC submits that Rule 12.2.4 of its Constitution confers a wide discretion on the NEC to dissolve the PEC where necessary. It seeks to persuade the court that the state of the organization, its governance, and the uprisings that took place in the Northwest during April and May 2018 created the necessity for the PEC in the Northwest to be dissolved. The ANC furthermore contends that because the NEC decision was taken in the exercise of its discretion in terms of Rule 12.2.4 of its Constitution, the standard for review for discretionary decisions must be applied, namely that a court can only interfere where the discretion was exercised on a wrong principle or was capriciously made. In other words, a court's power to intervene is limited to those cases where the exercise of the judicial discretion is vitiated by misdirection, irregularity, unlawfulness, or the absence of grounds on which the decision maker, acting reasonably, could have made the decision in question. In conclusion, the ANC argues that the very fact that the NEC, acting through the NWC, followed a process of consultation in the regions of the ANC and eventually came to a conclusion as to what decision to take without being beholden to the recommendations in the Mahumapelo report is a clear demonstration that it did not take its decision capriciously. It accordingly submits that there is no basis on which the NEC decision can be interfered with. I turn now to the issue of mootness. Now, in relation to its primary contention that the issues for determination are moot, the ANC argues that if the relief in prayer 2.4 of the notice of motion seeking reinstatement of the PEC within 7 days of the order is granted, it would have no practical effect because the PEC term of office will expire on 13 February. Coupled to this argument is that the other relief sought by the applicants is dependent on the declaratory relief sought, hence the court must refuse to grant that relief as well. The ANC contends that if the court were inclined to declare the dissolution of the PEC unlawful and order reinstatement of the PEC, such orders would have no practical effect whatsoever, as the term of the PEC will expire on 13 February. The ANC accordingly urges the court to dismiss the application on the ground that the relief sought is moot, as it will have no practical legal effect, if granted. Now, mootness is not an absolute bar to deciding an issue. In Van Wyk v. Unitas Hospital and another, Open Democratic Advice Centre, as amicus curiae, the Constitutional Court held as follows, and I quote, "It is by now axiomatic that mootness does not constitute an absolute bar to the justiciability of an issue. The court has a discretion whether or not to hear a matter. The test is one of the interest of justice. A relevant consideration is whether the order that the court may make will have any practical effect either on the parties or on others. In the exercise of its discretion, the court may decide to resolve an issue that is moot if to do so will be in the public interest. This would be the case where it will either benefit the large public or achieve legal certainty." Now, central to the relief sought in this matter is the question of whether the NEC's decision to disband the PEC violates the rights of the applicants. Violates the rights of the applicants in Section 19 of the Constitution. Political rights under Section 19 of the Constitution are fundamental rights in our dispensation. The question of whether the decision of the NEC to disband the PEC violated this right is of paramount importance to the larger public as well as to the ANC membership in general. The determination of this question will no doubt provide certainty for the future and serve to caution the NEC against acting unlawfully in the future as well. Now, there is a further reason why the relief sought is not moot. On dissolution of the PEC, the NEC was enjoined by Rule 12.2.4 to immediately appoint the PTT. The PTT would have, since its appointment, taken numerous decisions. This means that if the court were inclined to declare the NEC's decision to appoint the PTT unlawful and set it aside, there are bound to be consequences arising from the decisions taken by the PTT since its appointment. Therefore, at least some part of the application, particularly the consequence of the declaratory relief that may be granted, will certainly remain alive. There is furthermore no evidence before the court that the PTT has made any arrangements to convene a provincial conference on 13 February 2019 to elect a new PEC. So even if the PEC's term ends on 13 February and there's no provincial conference convened to elect a new body by that date, it is within the powers of the NEC under the Anc Constitution to extend the term of the PEC until such time that a provincial conference can be convened for the reinstated PEC to elect a new PEC. Should the NEC be disinclined to do so, then I would imagine that the PEC will remain in place until a new PEC is elected by the branches at a provincial conference in due course. Notably in this regard, the ANC Constitution makes no provision for an interim structure to be appointed between the expiry of the term of a PEC and the convening of a provincial conference to elect a new one. It is, however, not for this court to regulate the internal affairs of the ANC in light of a declaration of invalidity, which is inevitable if there is a breach of the provisions of the ANC Constitution. The ANC Constitution confers upon the ANC the power to regulate its own affairs, as held by the Constitutional Court in Ramakatsa and endorsed in Dube and others, v. Zikalala and others, the consequences that flow from a declaration of invalidity are best dealt with by the ANC itself in regulating its own affairs. Should the court be inclined to reinstate the disbanded PEC, however, this will not affect any rights which the NEC may wish to exercise, including the dissolution on proper grounds and subject to proper and fair procedures. Including the dissolution of the PEC on proper grounds and subject to proper and fair procedures. It follows from this that the issues for determination in this matter and the relief sought are not moot. I now turn to the issue of procedural fairness. Now, it is well established in our law that the principles of natural justice can be implied from the express terms of the contract of a voluntary association. In Psychological Society of South Africa v. Polani, the Constitution Court highlighted the considerations of legal policy that underpin the Audi Altrum Partem rule, which is the cornerstone of procedural fairness. It stated, and I quote, "It is trite at common law and in terms of the tenets of natural justice, hearing the other party, Audi Alterum Partem, is an indispensable condition of fair proceedings. The principle is underpinned by two important considerations of legal policy. The first is recognizing the subject's dignity and sense of worth. Second, there is a more pragmatic consideration. This is that Audi Alterum Partem inherently conduces to better justice." Close quote. Now, significantly, the application of the Audi principle plays an important and indispensable part in providing the depository of power with an opportunity to obtain information which may be relevant for the proper exercise of the power. Now, Section 19 of the South African Constitution provides, and I quote, "Every citizen is free to make political choices, which includes the right to participate in the activities of or recruit members for a political party. The rights in Section 19 of the Constitution are enjoyed through the membership of and participation in political parties." In Ramakatsa, the Constitutional Court held, and I quote, "In relevant part, Section 19.1 proclaims that every citizen of our country is free to make political choices which include the right to participate in the activities of a political party. The right is conferred in unqualified terms. Consistent with the generous reading of provisions of this kind, the section means what it says and says what it means. It guarantees freedom to make political choices, and once a choice on a political party is made, the section safeguards members' participation in the activities of the party concerned. In this case, the appellants and other members of the ANC enjoy a constitutional guarantee that entitles them to participate in its activities. It protects the exercise of the right not only against external interference, but also against interference arising from within the party," close quote. Now, the ANC is a voluntary association created by agreement. Its relationship with its members is contractual. The terms of the contract are found in the Constitution of the ANC, which is the mechanism through which ANC members exercise their Section 19 rights to participate in its structures and activities. The ANC Constitution is premised on the constitutional values of non-racism, non-sexism, and democracy, pertinently to ensure accountability, responsiveness, and openness. The ANC Constitution is binding on the organization and its members. There is a duty on the ANC to act lawfully and in compliance with its constitution. Any breach by the ANC of a member's rights will not only be unlawful under the ANC Constitution, but it will also constitute a violation of that member's rights under Section 19 of the Constitution, which entrenches the rights of citizens to form political parties and participate in their activities, including campaigning. The nature and scope of this right makes it clear that a constitution of a voluntary association must be construed in a manner which promotes the rights of members to procedural fairness when adverse decisions are taken against them. Now, Rule 7 of the ANC Constitution provides for the organizational structure of the ANC. Rule 7.1 specifies that the ANC consists of the National Conference, which elects the National Executive Committee, the Provincial Conference, which elects the Provincial Executive Committee, and the Regional Conference, which elects the Regional Executive Committee, and the Branch Biennial General Meeting, which elects the Branch Executive Committee. The NEC is the highest organ of the ANC between national conferences. The NEC has the authority to lead the organization subject to the provisions of the ANC Constitution. Rule 12.2.4 of the ANC Constitution outlines the powers of the NEC. It enjoins it to, and I quote, ensure that the provincial, regional and branch structures of the ANC and the leagues function democratically and effectively. The ANC may suspend or dissolve a PEC where necessary. The suspension of a PEC shall not exceed a period of 3 months. The election of a PEC, which has been dissolved, shall be called within 9 months from date of dissolution. The NEC must appoint an interim structure during the period of suspension or the dissolution of the PEC to fulfill the functions of the PEC. Now, Rule 3 of the ANC Constitution provides that the ANC is a non-racial and non-sexist and democratic liberation movement. Its policies are determined by the membership, and its leadership is accountable to the membership in terms of the procedures laid down in its constitution. Rule 17 of the ANC Constitution deals with the Provincial Conference. It provides the Provincial Conference is the highest organ of the ANC in each province, subject to the decisions of the National Conference and the National General Council and the overall guidance of the NEC. Rule 17.2.1 provides that the Provincial Conference shall be held at least once every 4 years and more often if requested by at least 1/3 of all branches in the province. Under the ANC Constitution, all properly convened conferences at the national, provincial and regional tiers are constituted as follows. At least 90% of the delegates of the conference shall be from branches elected at properly constituted branch general meetings. The number of delegates per branch shall be in proportion to their paid-up membership, provided that each branch in good standing shall be entitled to at least 1 delegate. All members of the Provincial Executive Committee shall attend ex officio as full participants in and delegates to the conference. The remainder of the voting delegates at the conference shall be from the members of the RECs, the ANC Veterans League, the ANC Youth League, and the ANC Women's League as allocated by the PEC. Branches form the basic structure of the ANC. Rule 23 of the ANC Constitution provides that a branch shall be the place where members exercise their basic democratic rights to discuss and formulate policy and be the basic unit of activity for members in the ANC. Rule 3.4 of the ANC Constitution provides that in its composition and functioning, the ANC shall be democratic, non-racial and non-sexist. The rights and duties of ANC members are spelled out in Clause 5. Clause 5.1.1 states that members are entitled to take a full and active part in the discussion, formulation, and implementation of the policies of the ANC. Rule 5.1.4 provides that members are entitled to take part in elections and be elected or appointed to any committee, structure, commission, or delegation of the ANC. Rule 5.2 in turn sets out the duties of members of the ANC. In terms of Rule 5.2.1, members shall belong to and take an active part in the life. A member shall belong to and take an active part in the life of his or her branch. The PEC is elected by members of the ANC. In terms of Rule 17.2, the PEC is elected at a provincial conference, which must be held at least once every 4 years. At least 90% of the voting delegates at a conference shall be from branches elected at properly constituted branch general meetings. Clause 12 provides for the powers of the National Executive Committee. The overall power is contained in Rule 12.1, which specifies that the NEC is the highest organ of the ANC between national conferences and has the authority to lead the organization subject to the Constitution. The word subject to makes it plain that the NEC cannot act in conflict or override the ANC Constitution. As indicated, the ANC Constitution places democracy, accountability, and membership participation at its center. It also specifies that the branch is the place where members exercise their basic democratic rights and that the branch is the basic unit of activities for members. Now, what is clear from these core provisions of the ANC Constitution is democracy is the ANC's grundnorm. In the words of retired Justice Moseneke, the ANC Constitution serves to domesticate the Section 19 constitutional rights of its members. Close quote. The powers of the NEC are not unconstrained. They are subject to the principle of legality, which has both a substantive and procedural component. Therefore, as relating to this matter, not only is the NEC constrained by the jurisdictional requirement to act where it is necessary to do so in Rule 12.2.4 of the ANC Constitution, but it is also constrained by the requirements of procedural fairness. It is clear from the provisions of the ANC Constitution that the right to a hearing before adverse decisions are taken is implicit. Importantly, in this regard, consultation and democracy are at the very heart of the organization. The basic unit from which a member's rights are exercised is the branch. As such, branch members who elect the PEC in the first instance are entitled as a matter of law to be notified and constituted prior to any decision to dissolve the PEC. Now, it is clear from the provisions of the ANC Constitution that the powers of the NEC to suspend or dissolve a PEC are not only constrained. Sorry, I'm just repeating that, beg your pardon. Sorry, I just stopped at the point where I said that branch members who elect the PEC in the first instance are entitled as a matter of law to be notified and consulted prior to the dissolution of a PEC in a province. It would follow, therefore, that the branches in the four regions, Bojanala, Ingaka, Modiri, Molema, Dr. Kenneth Kawanda, and Dr. Ruth Segomotsi Mompati, who elected the PEC in the Northwest Province in the first instance, were entitled as a matter of law to be notified and consulted prior to the decision of the NEC to dissolve the PEC in that province. The NEC contends that although it was not required to consult with the ANC membership in the branches and the regions, because Rule 12.2.4 of the ANC Constitution does not require to do so, it nevertheless did engage in a consultative process with the branches on 19 August 2018 at the consultative meetings which were convened in the four regions. Now, the departure point for procedural fairness is notice of the decision in issue. The question is whether the members of the branches or the PEC were given notice of the decision to dissolve the PEC. It is plain on the facts that none of these bodies received notice of the impending decision to dissolve the PEC. The invitation to the branches, RECs, and the PEC itself recorded the purpose of the NWC visit as to get an understanding of the provincial challenges and the state of the organization for its readiness for the upcoming general elections. This notice or invitation does not record any intention to dissolve the PEC. The so-called consultative meetings themselves were not meetings with the NEC, but rather the NWC, which has no power to dissolve the PEC. The purpose of the meeting is said to be an assessment of the state of the organization for its readiness for general elections. This means that branch members who attended the purported consultative meetings had absolutely no clue that the PEC would be dissolved. Under any interpretation, these meetings do not equate to consultative meetings with the branches on the question of whether the PEC should be dissolved. Branches were therefore not given notice of or consulted on the intended decision of the NEC to dissolve the ANC. Its failure to do so was in non-compliance with its own constitution and fatal. Now, the branches were also given a series of questions to answer at the meeting. Now, what is striking from these questions is that none of them deal with the functionality and effectiveness of the PEC. To the contrary, the questions related to branches, branch general meetings, disputes, suspensions, regional executive committees, and regional task teams. This is a further indicator of the misleading nature of the purported consultative process followed by the NEC. Had the NEC been serious about embarking on a genuine consultative process with the regions and branches concerning the functionality and effectiveness of the PEC in relation to the state of the organization in the Northwest Province, then it ought to have asked direct questions on the performance and effectiveness of the PEC. It is clear from the undisputed facts that these so-called consultative meetings did not meet the standard of procedural fairness as they were not properly convened. This much is clear from the undisputed facts, from these undisputed facts. First, the meeting at Ruth Segomotsi Mompati is described in the founding affidavit as having descended into chaos and having been attended by persons with no accreditation. Attempts to get the attendees to settle down failed, and the meeting degenerated into chaos. Banana peels and bottle caps were thrown onto the stage, and the NWC members walked out of the meeting and refused to proceed. None of these allegations are disputed by the ANC. Likewise, in relation to the Dr. Kenneth Kuwanda region, the same applies. In their founding affidavit, the applicants allege that there was a parallel structure that purported to conduct registration of people who were not members of the ANC. These people were not members of the ANC and had no authority to attend the meeting. Yet the Secretary General of the ANC, Mr. Magashula, allowed them to attend. The meeting was described by Mr. Magashula as a fact-finding meeting, and he did not raise anything concerning the dissolution of the PEC. These allegations are not disputed by the ANC in its answering affidavit. Although there is a purported dispute in relation to whether the 5 members of the branches who attended the so-called consultative meeting were allowed to speak, this dispute is not material to the allegations, as the ANC admits that it did not consult specifically on the issue of the dissolution of the PEC at these meetings. The explanation provided by the NEC in the answering affidavit, in the ANC's answering affidavit, is that it did not approach the consultation with a specific outcome in mind. That may be true, but once the NEC decided that the dissolution of the PEC would be the appropriate course of action, it was under an obligation to consult with the branches, which it failed to do. Now, the consultation meeting held at the Ingaka Madiri Mulema region suffers from exactly the same defects. In the founding affidavit, the applicants allege that the consultative meeting began at 900 hours. It was attended by Mr. David Mabuza, the Deputy President of the ANC. Upon his arrival, he instructed that the registration process, which was then underway, should stop, and everyone, regardless of whether their membership of the ANC was verified or not, should be allowed to attend. The applicants allege in their founding affidavit that this was unlawful and irregular. In addition, the applicants allege that the REC and NEC members who were in attendance at the meeting were not allowed to speak. The report of the region was not entertained, and the regional secretary was not allowed to present the regional report. Instead, members of other political parties, including opposition parties and non-invited members, were allowed to speak. Lastly, the applicants alleged that the questions of the NWC, which were listed in the questionnaire attached to the meeting invitation, were not addressed at this meeting at all. The NEC attempts to engage with these allegations in its answering affidavit through a report penned by Ms. Barbara Creasy, who was present at the meeting. However, Ms. Creasy prepared a report. Ms. Creasy did prepare a report of her observations of the meeting. This notwithstanding, the ANC does not deal with the substance of the applicant's allegations, in particular that non-ANC members were allowed to attend and to participate in the discussion at the meeting, and that the issues raised in the questionnaire were simply not attended to. Now, the situation that prevailed at the so-called consultative meeting, which was held at Bojanalo, was no different. The applicants allege in the founding affidavit that the regional secretary was not allowed to speak and present her report at this meeting. It is also alleged that the meeting turned chaotic and the credentials of the people who were allowed into that meeting were not verified. The answering affidavit virtually admits these allegations. In particular, it accepts that the meeting was rowdy and non-members were allowed to attend. It, however, seeks to justify the dissolution by alleging that there were divisions at the meeting which the PEC was obliged to resolve. There is no merit in this contention. The so-called consultative meeting simply failed to fulfill the function of consultation, which was to provide a platform for the NEC to satisfy itself as to the appropriateness and necessity for the decision that it intended to make. In short, the so-called consultative meetings were symbolic, chaotic, and rowdy. They were furthermore not properly convened. They accordingly did not meet the basic requirements of procedural fairness. Lastly, the NEC did not provide the applicants with reasons for the decision. This is a further ground on which the decision was unprocedural. The NEC states that the reasons for the dissolution were clearly spelled out in Annexure AM3. Annexure AM3 is a copy of the press statement issued by the Secretary General of the ANC. It is headed Dissolution of the North West Province Executive Committee. This, in my view, is a cryptic document which reads exactly like a press statement and is indeed a press statement. What it does not do is provide reasons for the dissolution of the PAC. The opening paragraph simply records that, and I quote, "The special session of the NEC resolved to intervene in the Northwest Province to strengthen the organization and enhance its capacity to meet its mandate to the people of the province." If the reason, close quote. Now, if the reason for dissolving the PEC was its dysfunctionality and ineffectiveness in the Northwest, or the violence and torching that occurred in April and May 2018, then those reasons should have appeared in the press statement, which on the ANC's version are the reasons for the decision. It is disingenuous, in my view, for the ANC to argue that the press statement constitutes reasons for the decision. In the premises, I'm of the view that the decision of the NEC to dissolve the PEC did not meet the basic requirements of procedural fairness, which is contemplated in both the ANC Constitution and the Constitution of the country. The dissolution of the PAC is a drastic and draconian measure that ought to have been resorted to as the last resort. The ANC acknowledges as much, but did not deem it necessary to notify or consult with the branches before finalizing its decision, nor did it give the members of the PEC a hearing. Moreover, it failed to give proper reasons for dissolving the PEC. For all of these reasons, I find that the decision of the NEC to dissolve the PEC is procedurally unfair, in breach of the ANC Constitution, and in violation of the applicant's Section 19 constitutional rights. The applicants are accordingly entitled to the declaratory relief sought in prayers 2.1 and 2.2 of the Notice of Motion, declaring unlawful and setting aside the decision of the NEC to dissolve the PEC and to appoint the PTT, respectively. While a declaration of rights is important, it is not sufficient where the conduct of the respondent is unlawful for being in non-compliance with its own constitution, as is the case here. Now, leaving the PTT in place as contended for by the ANC will be to preserve an illegal state of affairs in the absence of any explanation from the ANC as to why the court should countenance such illegality. A party seeking to preserve an illegal state of affairs must explain precisely why a court should countenance that illegality. The relief granted by a court must not only be just and equitable, but it must also be effective. The applicants are therefore entitled to the consequential order asked for in the notice of motion, to the consequential orders asked for in the notice of motion, namely the interdictory relief and an order reinstating the disbanded PEC. The ANC has once again produced no evidence why such an order would not be just and equitable. In view of this conclusion, I see no need to deal with the merits of the application. I now turn to the issue of costs. The individual applicants have brought this application to vindicate their constitutional rights under Section 19 of the Constitution. They have had substantial success. I therefore see no reason to deprive them of their costs in this application, as well as the reserve costs of 20 November 2018. In the result, I make the following order. 1. The decision of the ANC made on 31 August 2018 to disband the Northwest Provincial Executive Committee is declared unlawful and set aside. 2. The decision of the NEC of 20 September 2018 to appoint a provincial task team is declared unlawful and set aside. 3. The PTT is interdicted from carrying out any of the functions conferred on it by the NEC and the ANC Constitution. 4. The disbanded PEC is reinstated within 2 court days of this order. 5. The ANC is ordered to pay the cost of the application, including the cost of 2 counsel. 6. The ANC is ordered to pay the cost of 20 November 2018, including the cost of 2 counsel. It is so ordered.
Provincial Executive Committee of the Northwest was unprocedural and unlawful. One of the men at the center, of course, of the application that was brought to this court is Supra Mahumapelo, was also subsequently axed during that decision. Mr. Mahumapelo, thank you very much for joining us. Your reaction, first of all, to the court's outcome.
Well, thank you very much. Firstly, we are not elated because in the first place, we were not supposed to be here today. The leadership of the African National Congress in the National Executive Committee just paused and reflected a bit on the issues that we were raising when all the machinations were in motion to ensure that the PEC gets to be dissolved. So we are not happy because when you elect a National Executive Committee, it must take its political work serious. The National Executive Committee must make sure that before you arrive at such serious decisions, you pause, you take time, you reflect on the possible political implications of your decision, and you look at many other options before you can take such a draconian decision. So we have not been saying that the NEC doesn't have the power to take that decision. Our matter always has been political procedural fairness, and today the court has confirmed that. So we hope that this will provide an opportunity for us to listen to one another with our National Executive Committee, and where we made mistakes, those mistakes must be corrected, allow the organization to be united, and allow the ANC in the Northwest Province to prepare for victory in the elections in May.
Certainly, from what we saw happen in the Northwest, of course, preceding this court application that you brought, there seemed to be a lot of division within the Northwest, pertaining, of course, to your leadership there, those who believed that you should go. What do you think would be the implications now? You spoke about implications for your movement itself. What do you think the implications will now be, given that you've now won this case, and this is a province where there are people who also believe that you should have left?
The quest for unity in the African National Congress is like a road that is perpetually under construction. So you will never arrive at a stage where you say you've got total unity, because the conditions under which you pursue such unity change all the time. That's why you need to appreciate those differing ideas within the African National Congress actually as a strength to the African National Congress, and use that to strengthen the organization. Rather than when you see political differences, you then come in and use the political differences to get at other comrades. It doesn't help the revolution done in that way.
So do you believe now, of course, part key to what you brought to this court was the fact that you believed that the dissolution of that Provincial Executive Committee was nothing based on politics, and simply because, amongst others, you did not support Cyril Ramaphosa at the run-up to Nasrec? Well,
it's not about Comrade Cyril Ramaphosa. The point we have always been making is that before we went to Nasrec, there were people in the province who were being mobilized to say the PEC must go. At Nasrec, as soon as the results were announced, people started to make pronouncements inside the hall to say that now the opportunity to get rid of the PEC has arrived after the announcement of the top 6 officials. Immediately after the national conference in Nasrec, people started intensifying the campaign. We took pains to go as the provincial officials to see the NEC officials in February last year, and we said to them, this is an analysis of our situation in the province, please intervene. And they said they'll come back to us. Until today, they are still coming back to us.
What does this mean for the meeting that you had with the ANC Secretariat? You did say in the last court appearance, when judgment had been reserved, that you had met with the ANC Secretariat, and basically you would now chart a way forward following this judgment. What are you expecting the ANC to now say?
Well, we are an organization that abide by the rule of law in South Africa. So I don't expect the national leadership of the ANC to do something that is against the Constitution of the Republic. Because the National Democratic Revolution brought about the Constitution of the Republic. And therefore, for us to be having this Constitution, it means the National Democratic Revolution has achieved some of its objectives. Therefore, we will listen to the national leadership of the ANC. We are members of the ANC. We strive to be disciplined at all times. And during those discussions, we will see where to from now. But remember, at the center of everything that we do must be the masses of our people who express their rights through the branches of the African National Congress. So it's important as we move forward to remember that whatever we do, it is basically the membership of the ANC that must give us direction. And as leadership, having listened to the direction that is coming from the ground, from the membership and the branches, we can then say, this is the way forward. But what I'm saying is, what is urgent now is for us in the province to bring everybody together and work towards a decisive victory of the ANC in the May elections. Pointing fingers and saying so-and-so has done this and so-and-so has not done this is not going to help the revolution. But I hope that our leadership will be candid and humble enough to say, we may have thought we took the right decision, but procedural fairness was fundamental for us to have arrived at that decision.
Are you saying then that unity with the ANC currently is a fallacy, given the fact that in this particular judgment by Judge Catherine Sitluwane, she did say that the ANC had basically violated its own constitution?
Well, I'm not saying unity is a fallacy. I'm saying unity within the African National Congress is something you work on perpetually. As long as we exist in this organization, we work for unity. That's why we were formed in 1912 as the African National Congress. The basis of the formation, the pillar of the formation of the ANC was to unite the people of South Africa. Therefore, we'll always strive for unity. No matter how difficult the situation is, we must put the unity of the organization first. And we're saying to the NEC, you dissolving the PEC will not bring unity. The extent of the instability now in the province is shocking. Some of them in the NEC are now admitting, privately of course, that the decision was not the best decision under the circumstances. Their own PTT they put in place. And we had told them that these people that are putting in the PTT, they are lazy, they don't do organizational work, they just wanted to be in positions. As we speak now, they are now in 4 splits within that PTT. Therefore, they must still be helped themselves to come together now as ordinary members of the branch. We have always said in the PC about these comrades who are crying that they are being sidelined and so on. We have always said, let's convene branch meetings in your own areas. Come to the branch meeting and say in front of everybody that I'm being sidelined by the leadership of the PEC, so that not the PEC, but the membership, if they are convinced and they agree with you, they must say, indeed, we are sidelined and therefore the PEC is wrong. It must not be individuals who say so, it must be the branch to which you and me should be belonging to.
With such divisions that you speak of, are you concerned at all, finally, about the reception that you will receive once you return?
Oh, I mean, in the organization, I have faced many challenges over time. And it's not about me. It's about the collective, and above the collective is about the African National Congress. And at the center of what is it about the ANC is about the masses of our people.
Are you worried?
In the Northwest Province. I'm never worried about anything. I've passed the stage of anxiety, of worry in my life. I've passed that stage long time ago. I don't worry about anything.
All right, thank you very much for your time. Supra Mahumapelo, of course, they're saying he's not concerned about anything at this stage relating to the victory that he has scored inside this court here today. Of course, Judge Catherine Sitluwane indicating that the decision that was taken by the ANC NEC was unconstitutional and unprocedural. A victory for him, considering the fact that we'd seen in the run-up to the unrest that we saw in the Northwest, there were factions within that particular province, but with the PEC itself being dissolved, Supra Mahumapelo says now he returns, and in fact part of that judgment that was delivered here does indicate that this ruling needs to be effected within 2 days of this ruling, and that basically the PTT itself is not supposed to carry out any work that it is given by the National Executive Committee. But we'll post it back to you in studio for now.
Why do you keep on defending?
I know.
No, I can't say so. Let me also interview the rest of you.
The applicants.
No,
Let's go outside.
Applicants, good morning.
All right, can we get going?
I knew that they didn't have the merits.
I was telling this one, we were discussing which side if we were betting. This one is not a good bet.
He lost. But I told